Hi, welcome back to Intellectual Property. Today we're going to be talking about the really most fundamental requirement for patentability, that is novelty. In other words, as the Supreme Court has said many times, patent law only protects and can only protect novel inventions. In other words, patent protection can only extend to things that are actually new, and patents can't protect things that aren't new, right? Because the entire point of providing patent protection in the first place is to encourage investment in the generation of new inventions or discoveries, and to encourage disclosure of new inventions or discoveries. In other words, we want people to do new things and we want people to disclose new things. And if something isn't new, then there's no benefit to the public if we subsidize it indirectly through patent protection. In other words, the patent quid pro quo, the something for something, can only be satisfied if the public is getting something in exchange for extending patent protection. And that something is investment in innovation and disclosure of innovation. Okay, well, how does that work in practice? Well, under the Patent Act of 1952, we looked to novelty as of the time of the invention or discovery itself, right? In other words, the moment of actual discovery was what defined who would be entitled to patent ownership, and therefore you were only entitled to patent ownership if the invention or discovery that you were applying to patent was in fact new when you invented or discovered it. Under the America Invents Act of 2011, the time frame has been shifted to some degree, right? So novelty is as of the time of filing rather than as of the time of invention or discovery. So essentially, the entire time frame of patenting has shifted from a first to invent to a first to file system. Of course, there was considerable contention over whether that was a sensible or appropriate move, but essentially it sort of reflects the idea that we want to encourage disclosure as early as possible. And to the extent that we think the primary virtue or primary value of patenting is disclosure, moving to a first to file system encourages early disclosure rather than later disclosure, right? So novelty, again, moved from the moment of invention to the moment of application, with certain kind of safe harbors, as it were, for the person filing the patent application. In other words, there are certain exceptions that permit a patent applicant to either delay application or delay disclosure, and we'll talk about those later in the class. Now, the key point when it comes to novelty, right, as a requirement for patent protection is that, a non-novel invention or discovery can't be patented, and accordingly, the patent examiner has to determine whether or not an invention or discovery is in fact novel. And in fact, that's the primary role, or one of the primary roles of a patent examiner, is to investigate whether or not the invention or discovery disclosed and claimed is in fact novel and therefore entitled to patent protection. And in order to do so, they have to look to what people have done before. In other words, they have to look to what fazitas know about the state of the art. They have to look to what's been previously disclosed, and they have to determine whether or not a particular invention or discovery is in fact novel. And they can look, at least in theory, at basically anything. However, in practice, primarily what they look to is previously filed patents, right? So you'll see in every patent document, if you flip back to the ones we've looked at in the past, right, that they include a section devoted to prior art, right? And that prior art section is, on one level, evidence of the patent examiners, like essentially doing their work, right? It says patent examiner look to these prior disclosures, and that would be primarily patents, although not exclusively. It can include all manner of other kinds of disclosures, including academic papers, what have you, right? And it says, look, this is what we look to as prior work in the field that's relevant to the invention or discovery in question, right? And you can look back to those to see that we did our due diligence, looking back through the patent record to determine what had been previously patented. Prior art does something else too, though, right? It also helps people looking at the patent document understand the limitations of the patent. In other words, when you look to the prior art, you can determine what was non-novel at the time the invention or discovery was patented, and therefore what the invention or discovery doesn't include. Okay, so what counts as prior art? Well, for the purpose of patentability, a prior disclosure counts as prior art so long as it discloses the invention or discovery in question and enables it, right? In other words, the requirements for prior art are identical to the requirements for patentability. It's all about the disclosure, right? It's all about whether or not a particular invention or discovery was already available to the public prior to the disclosure in the patent document in question. Okay, well, how does that work in practice? What do we look to? What do we think about in determining whether a particular invention or discovery actually anticipates a patent filing, and how do we determine whether or not a patent filing is in fact, or a patent application is in fact eligible to be granted? Well, let's look at the titanium metals v. Banner case. Okay, so what happened here? The patent applicant is claiming a particular titanium alloy, specifically a titanium base alloy containing a certain percentage of nickel, a certain percentage of molybdenum, and a certain percentage of iron, with everything else being titanium. And that alloy has certain corrosion-resistant characteristics in hot brine environments. But they're also claiming just the alloy itself, right? So they're claiming a particular composition of the alloy and then describing something that the alloy actually does. Okay, so they submit this patent application and the patent office ultimately denies the application. Why is that? Well, they point to a prior publication, right? So there's an article in a Russian metallurgy journal, right, an academic journal in Russia, written in Russian, right, that describes precisely the same alloy. In other words, somebody has already produced or described the production of the alloy in question. They've disclosed the particular alloy that's being claimed, made statements about the alloy, right, and effectively enabled Fazitas to produce the alloy as well. In other words, simply, really, according to the patent office and according to the court, simply by disclosing the alloy in question, any Fazita would know how to make it, right? In other words, the patent applicants can't claim the alloy, right, qua alloy, because it's already been disclosed by prior art that both discloses the alloy and enables the production of the alloy. Now, what's complicated about this particular opinion? Well, a few things, right? For one, the article in question doesn't literally exactly disclose precisely the same alloy that's being applied for patentability by titanium metals, right? So it's not identical, but effectively the court says, look, it's close enough, right? It's close enough such that the alloy disclosed is sufficiently similar to the alloy claimed that a Fazita would be able to make that leap, right? So even though it isn't exactly identical with respect to all of the claims, with respect to some of them it is, but with respect to all of the claims, it isn't exactly identical, and therefore a Fazita would be able to see how that claim would be made, right? So for the first couple of claims, they actually literally disclosed the alloy in question, although it was kind of more of a crossover of ranges. It didn't disclose claim 3 in the article, but they disclosed close enough, right? So we've got a distinction here, a helpful distinction, hopefully, between novelty going to claims 1 and 2, where it's actually literally disclosed in the article in question, although again, there's some crossover, but the article actually discloses a version of the alloy that they're claiming. By contrast, it doesn't literally disclose the alloy quality disclosed in claimed in claim 3, but it's close enough that it would be obvious to a Fozito working in the area that you could make that choice. So the problem here is that titanium metal wants to claim the entire alloy, wants to claim the exclusive right to make this particular alloy, this particular combination of metals as a whole, right? And the court says no, the patent office says no, that alloy in question, the alloy you want to claim an exclusive right to make, has already been disclosed by someone else, and therefore you're not entitled to claim it. So my question for you to ponder prior to our class on Tuesday is, if you were Titanium Metal's lawyer, right, if you were helping them prosecute this patent, how would you change the claims, or how would you frame the claims in order to make them valid despite the pre-existing article? In other words, is there any way you could write these patent claims to avoid the prior art and make a novel claim rather than a claim that falls afoul of the novelty requirement? Right? In other words, what would you do in order to make this patent application valid, right? And again, or rather more to the point, why do you think the patent applicants framed it this way as opposed to some alternative way that would make it valid? In other words, what were the incentives for the patent applicant here? Why did they choose to do it the way that they did? And did they make a good choice or a bad one?